Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-1143, GMS Mine Repair Petitioner versus Federal Mine Safety and Health Review Commission and Secretary of Labor, Mine Safety and Health Administration, MSHR. Mr. McHugh for the petitioner, Mr. Wilson for the respondent, Secretary of Labor.
Mr. McHugh, good morning.
Good morning, Your Honor. My name is James McHugh, and I represent GMS Mine Repair, and I would request 2 minutes for rebuttal. GMS appeals from the decision of the Federal Mine Safety and Health Review Commission, ALJ, interpreting 30 CFR 100.3C. In this case, GMS had 5 citations prior to the citations that were penalized in the previous 15 months. However, according to the Secretary's reading of the regulation, they were penalized as though they had 15 or 16 violations in the 15 months period discussed in 30 CFR 100.3C. In other words, during the look-back period in the regulation, they had 5 citations, but they were penalized for 15. This resulted in a 100% increase in the penalty for GMS. In this case, GMS contends that the ALJ erred in failing to apply 30 CFR 100.3C as it's written, and also erred in failing to apply the analytical template in Kaiser versus Wilkie, which requires a multi-step process before declaring a regulation to be ambiguous. In this case, the judge just basically said, well, I look at this side and I see this side and I'm going to declare it ambiguous.
But I didn't find that your request, it seemed like it also was somewhat ambiguous because you gave us a few ways to look at this. So I'm not sure what you've actually settled on in terms of the interpretation.
Yes, Your Honor. GMS contends that there's a very clear 3-step process in the regulation. There's 2 sentences at issue in the regulation. The first sentence talks about the violations that occur in the previous 15 months. 2 key words in there: violation, which means an occurrence under Webster's, and in, as opposed to outside of. The Secretary wants to apply it as outside of the 15-month period. The second step is the next sentence, and that is, of that set of violations in the 15-month period, those that are not final are removed. This we call the due process step. And the key word there is the word only. That qualifier shows quite clearly that that sentence was intended to apply to the previous sentence and remove those regulations which are not final that occurred in the previous 15-month period.
So is I know that you have a third step about repeat violations, which doesn't seem to be an issue here. But just to follow up on Judge Child's question, as you just read it, it sounds like it talks about violations and the violations occurring within a 15-month period. And I had understood your argument to be, and tell me if it's incorrect, that the violation has to be assessed within the preceding 15 months and then finalized for that second sentence. Is that right?
Our position, Your Honor, is that the violation has to occur first, and then when a violation occurs, it's cited.
I'm sorry, citation, not assessed, excuse me. So you think even if the citation had occurred within 15 months, but if the violation hadn't, that would be out? Because I understood your argument to be citation to finalization have to be in 15 months, but the act that's in dispute, the act that's charged to be violating the law doesn't have to be within the 15-month period. Can you clarify whether the violation also has to be in? Because that would be very different from how I understood your brief.
I'm sorry. Yes, our position, Your Honor, is the violation itself must occur within the 15-month period, because a violation, they use the word violation, they chose to use it. But by Webster's, it means the occurrence of a violated condition. So it has to occur within the 15-month period. And then, of course, it's set cited, usually on the same day, not always, but usually. And then oftentimes it's paid. 80 to 90% of them are paid immediately when there's assessed. Assessment comes a little bit later. But our position is it's the violation must occur in because we're following the regulation.
So you have to have violation and citation and finalization of the process in whatever form it finalizes itself.
Yes, Your
All
Honor.
within 15 months. 'Cause a
Correct.
lot of your arguments were about, as I understood them, were about the citation having to be there. And right on page 21 of your brief, and you keep talking about issued violations, and I don't know what an issued violation is. And so, but just to make clear, so citation isn't enough. It has to be the act of violation, because that's, your brief is not, that's not how I understood your brief.
Okay, I apologize if we didn't make that clear, but that is the intent, is that the violation has to occur within the 15 months, because that's what's stated. And then, of course, it's cited. Most of the time, 95 or more percent, it's the same day that it's the violation occurs. And then,
Sorry, how often is it the same day the violation occurs?
well, I'm just going off of my total recollection. I don't think it's
No,
in the
so you don't have any record evidence on how often that happens?
It's not in the record, Your Honor.
But then how does citation play into what you're asking too? Because if it's not occurring the same day, it seems like that throws off the math as well.
Yes, Your Honor. Very few. I mean, the Secretary, of course, has the data on this, but very few are not cited the same day.
I know, but citation's not in here,
Right.
but you're using that term.
Yes, Your Honor. I agree. I'm using that term because the citation is the written record of the violation. And I mean, there's no way practically to know if a violative condition occurs unless there's a piece of paper that goes with it. That's kind of the way we interpret the word violation using Webster's dictionary. And also the way the
Well, Webster's doesn't define, I'm sorry, it doesn't define a citation as a violation.
No, Your Honor, it does not.
Okay.
It does
I'm
not.
sorry.
All right, what work then, in your interpretation, does the word assessed in the second sentence?
The word assessed, it means once the citation is issued, it does take the Secretary a brief period of time before it's assessed by the MSHA points, the MSHA penalty office. I can't remember what the name of it is. They take the citations in and then they assign, you saw the Exhibit A in here they apply Part 100 and crunch the numbers and come up with an assessment.
All right, so your position is the first sentence, by use of the word violations, sets the date of occurrence.
Yes, Your Honor.
And then the only assessed violations in the second sentence refers to when the citation is actually issued?
No, the assessed in the second is that's like, we call that the due process clause that was tacked on to the first sentence. You have the subset of those violations, which are in paper and citations, and then those that are assessed and final get removed, or not, excuse me, I'm sorry, I misspoke. Not assessed and final get removed because they haven't been proven yet in court or haven't been admitted to.
Non-assessed and final, isn't it assessed and non-final? Or, I mean, the assessment
The
tied to the final order. The assessment, well, go ahead. What is the assessment? When does that occur?
You're right, Your Honor. It occurs just a short period of time after the citation has been issued. It is not a final, definitely, until it's admitted, either in when they send it, the operator sends in their contest and they say, we admit these and we deny this one or two.
All right.
And so it's assessed at that point, but it's not final until they.
So assessed relates to the fine.
Assessed relates to the fine. Yes, Your Honor.
Okay.
Absolutely. I'm sorry, I didn't make that clear. I see I'm down to my rebuttal time.
All right, we'll give you a couple minutes. Mr. Wilson?
May it please the court. Good morning. My name is Robert Wilson. I represent the Secretary of Labor and the Mine Safety and Health Administration. I agree that there is a three-step analysis to be applied in this case, just not the one that GMS made up. Proper analysis is what the Supreme Court articulated in Kaiser v. Wilkie. Under that holding, there are three issues that need to be addressed. One, whether section 100.3C is ambiguous with regard to when violations are included in an operator's history of violations. It is. Number two, whether the secretary's interpretation of section 100.3C is reasonable. It is. Number three, whether the secretary's interpretation merits deference. It does. And then a fourth issue in this case is whether the administrative law judge committed any errors material errors when he granted the secretary's motion for summary decision and denied GMS's motion for summary decision. He did not.
And can't this court do that Kaiser v. Whitney analysis? We don't need to send it back.
I'm sorry, Your Honor?
Can't we do that analysis here?
Yes, Your Honor.
As opposed to sending it back? As
Yes,
opposed to sending it back?
Your Honor.
Okay.
Yes. There are a couple of facts I would like to emphasize for the court. First of all, the company does not contest that they committed any of the 5 violations at issue in this case. They stipulated to all of the penalty criteria other than history of violations. They stipulated that 3 of the 5 violations were significant and substantial, which means that they had a reasonable likelihood of resulting in serious injury or death. The other point is that under GMS's interpretation of the regulation, none of these violations would ever be included in their history of violations, simply because they took more than 15 months to become final.
Can I ask you, if you know in your experience or your client knows how often citations are issued on the same day as a violation?
I don't have a percentage, Your Honor, but as we pointed out in our brief, there are several instances when citations are not issued when violations occur. And the most prominent of those situations are fatal accident investigations, which is the most serious type of incident under the Mine Act. People die. And clearly the violations occur when the accident occurs, not when the citation is issued several months later. And I think that—
Sorry, so citations can come even months after violations, including serious violations.
Well, as an example, Your Honor, we cite in the brief to the Upper Big Branch tragedy where 29 miners lost their lives. And that occurred in April of 2010. By the time the investigation was completed and contributory citations were issued, that was December of the following year. So under GMS's interpretation, by the time those violations were issued, they'd already be excluded from an operator's history of violation. That cannot be what was intended by Congress or by the Secretary when this regulation was promulgated.
So is the sequence first the occurrence of the violation, then the citation, which may be the same day, it may not, then the assessment, which may attach to the citation, but not ever be the day of the occurrence?
Yes, Your Honor. And as we argued in the brief, I mean, the violation is basically a life of a violation from when the violation occurs all the way to when it becomes final. And in between that, you have the citation is issued. Sometime after that, a penalty is assessed for the citation. The operator then contests the assessed penalty. So now it's a contested violation. And section 100.3C simply says violations. It doesn't say citations. And I think, counsel was confusing those two issues here today.
And the gap between, so you have the violation and then there can be a gap. It could even be, I guess, sounds like a year or so, a gap between violation and citation, especially in serious cases. And is there a general estimate or estimate on the gap between the citation and the assessment?
Your Honor, in the preamble, it noted that on average, it takes about 3 months for a regular assessment to be assessed. And a regular assessment is where we go by the points, which is what we're dealing with in this case. But there are other cases that may be specially assessed, which may take longer than the regular assessment.
Can I ask you, since we're talking about the preamble, the sentence that says MSHR reviewed violations that were assessed in 2005 and determined that because it takes approximately 3 months, so on and so forth, would provide the agency with at least 1 full year of data. That to me indicates that it's going to reach back further that there could be more than 1 year. In other words, it supports your reading of it.
Yes,
At least, in other words, it wasn't just 1 year, it was at least 1 year, and it could be 2 years.
yes, Your Honor. And that provision of the preamble was addressing comments where the new rule, when this rule was promulgated, reduced the period of time that was being looked at from 24 months to 15 months. And commenters raised a concern that that wasn't going to give enough time for a full consideration of the operator's history of violation.
And speaking of that, under the Big Mine citation, that occurred years later. And so how does that fit the kind of intent of the statute to get these repeat violations and/or problematic violations for purposes of the assessment? Because that citation violation occurred years later.
Years after the
Yes.
citation came from 20 months after the violation.
Right.
Right, and that's part of the problem here with GMS's interpretation, that violations, I mean, the most serious violations under the Act would never be considered as part of an operator's history of violations. And that's clearly directly contrary to what Congress intended. As this court held noted in Coal Employment Project versus Dole, Congress was intent on assuring that civil penalties provide an effective deterrent against all offenders, and particularly against offenders with records of prior violations. And so what GMS's interpretation would do is it would defeat that intent by excluding valid violations from an operator's history simply because they took more than 15 months to become final. It would be
How long has the Department of Labor had the position you're arguing here, your interpretation of the regulation? How long has that been the interpretation the Department of Labor has had and has applied and enforced?
always.
Since it was first written, which was when?
I'm sorry?
Which was when? When did always start?
Well, with the promulgation, this current rule was promulgated in 2007, and that was the position of the secretary ever since then. And it is clearly articulated in the preamble, which obviously was issued at the same time that the rule was promulgated. And in the preamble, during notice and comment, there were concerns raised that using only final orders would encourage mine operators to contest violations simply to eliminate them from their history of violation. Exactly what GMS is trying to do in this case. And in the preamble, the secretary said, quote, as each penalty contest becomes final, however, the violation will be included in an operator's history as of the date it becomes final. The secretary's intent could not be any clearer. And the secretary's interpretation has been consistent ever since then. As the commission administrative law judge found, another problem with GMS's interpretation is it would encourage contests of violations. And we all know that litigation takes time. By the time you go through discovery and depositions, you go to a hearing, you wait for the transcript, you file a brief, so on and so forth. 15 months goes by like that. And as we pointed out to the ALJ, and as he cited to in his decision, on the commission's website, they list all their decisions. And the 10 most recent ALJ decisions where a case went through the hearing process, all of them took more than 15 months to be final. In fact, in GMS's brief, all of the cases that they cite to took more than 15 months to become final, except for one, which we note in our brief.
And GMS argues that if we were to get to the Kaiser factors, that this doesn't implicate the secretary's expertise, this regulation or its interpretation, that it's just sort of a procedural thing. How would you explain, how can you tie this to this interpretation to the agency's expertise?
Yes, Your Honor, and this very court addressed that issue in Doe versus SEC. And
well, we didn't talk about the secretary expertise on mining in an SEC case. So I really wanted to know exactly what on the ground here, what in reality would make your expertise implicated.
Well, Congress authorized, not only authorized, but ordered the Secretary of Labor to promulgate regulations to implement the civil penalty process. And so Congress entrusted the secretary with that task. And so that puts it within the secretary's expertise.
What is the connection between enforcing a civil penalty process and the secretary's clear duty to promote mine safety?
Well, the ultimate purpose of the Mine Act is to promote safety and protect the health and safety and lives of miners. And what civil penalties do is they provide an incentive for mine operators to comply. Further, more compliance leads to fewer violations, fewer hazards, which leads to fewer deaths and fewer injuries.
And so then the concern is that under GMS's view, there would be less enforcement and so less incentive to promote safety.
Yes, under GMS's interpretation, an operator could simply contest violations, drag out the finality for more than 15 months. Those violations would then never be included in an operator's history of violations, which would reduce penalties, which Congress recognized is an incentive to comply. And so therefore it would reduce compliance, increase hazards and violations.
And to what degree is the secretary's interpretation really just kind of a policy-laden choice?
Well, I mean, to an extent, there was a policy decision made by the secretary that they would include final violations in the look-back period and not, as we discussed, issued or occurrence date or assessment date. They would look at the final date, which corresponds with the second sentence in the regulation.
And then we also have in here that it becomes final within the relevant 15-month period. So discuss with me the periods of assessment, if you will, because obviously it's almost like a statute of limitations in what comes within that period and what's outside of that period. So what are those kind of periods of assessment points?
Right. So it varies from case to case. Like I said, in the Upper Big Branch case, it was some 20 months between when the violation occurred and when the citation was assessed or when the citation was issued. And then most violations are assessed a penalty sometime after the citation is issued. As the preamble said, average time is 3 months, but it can be more or less than that. And then how long it takes for that to become final is just up to the individual case. We pointed out in our brief, there were instances where violations did not become final until 10 years later.
And I guess I'm asking the question a little differently. When are you trying to capture the information? Like at what points in time? When is it relevant or matters to the Secretary of Labor about these violations? Are there certain reporting periods?
The date when the violation is included in an operator's history of violations is the date it becomes a final order of the commission. In other words, when it is finally resolved. And that takes into account the due process concern that it wouldn't be fair to mine operators to include violations that may later be vacated. Mm-hmm. I see my time is way beyond.
All right, thank you.
Thank you very much.
Mr. McHugh, why don't you take 2 minutes?
30 CFR 100.3C is a policy decision by the Secretary. They made a very specific policy decision when they drafted it the way they drafted it. Nowhere in the Secretary's argument does the Secretary explain where in the regulation it says that you can include violations that were issued 4 years ago. If you read the preamble, it's quite clear that what they wanted to do, and the policy decision was for history, we need the most recent violations. If you look at the part in the preamble about repeat, it becomes very clear. They said, we want to look back at the last 3 or 4 inspections and see if they're doing the same thing over and over again so we can determine if they've violated, if they've got a bad history. And that's exactly what the preamble did. Like I said, the regulation itself mentions a 15-month period in connection with violations in. It doesn't say 15-month period violations outside.
Okay, so page 21 of your opening brief, where you first tell us what your step one is, you don't talk about the violation, you talk about the citation. Step one, the regulation considers the date of the citation
Yes,
at
Your Honor.
issue. And then you go down, any citations issued more than 15 months prior to the citation dispute will not count, because under the clear standard, only the citations issued in the preceding 15 months are part of the universe of relevant citations in the first step of the process.
Yes, Your Honor.
But your argument this morning hasn't been what your blue brief says. It has been the violation rather than the citation. And you've come to us with a plain language argument, but now I'm seeing your plain language shifting from your brief to your oral arguments. So how can it possibly be plain if you're not even using the same language in your brief that you're using at oral argument?
Your Honor, because citation is the only record of a violation. There can be a violation at the mine today, but nobody knows about it. It's underground. No one sees it.
That's exactly the point. The citation could come later. They find out about it later. A miner complains. Someone reports it.
Yes,
Maybe the owner is good and reports it.
But in this case, normally what happens is I know there's situations with accidents where it comes later and there's an investigation, but those are like the sky's falling situation where the vast majority of these things happen right on the day.
Yeah, but they're right that those would not be included in the history for your purposes.
Right.
And why would Congress not want the most serious death-causing violations not to be included in the history of violations?
Your Honor, obviously the Secretary had the ability to draft policy on penalties, and they did that when they drafted 100.3. They made a policy decision that they wanted to get a recent snapshot as opposed to a holistic over the length of a long period of time.
Well, as Judge Henderson said, they said at least 12 months. That doesn't mean they're confined to the 12-month or 15-month period. She pointed out at least reaches further back than that.
My reading of the sentence that the court mentioned was that it's got a 15-month period that in response to the questions in the preamble, they said it normally takes 3 months for the citation to become final, and therefore we'll still have a 12-month snapshot, and we'll still have a 12-month history, and that's what we want to do. And oh, by the way, we're adding this repeat section that wasn't in there before to counterbalance the fact that we've reduced the snapshot, the 24 months to 15 months. So there was a trade-off, a policy trade-off when they drafted the regulation. And it's very clear in the preamble how they came to that conclusion. Also, as far as these serious violations, the history under Part 100 doesn't mention anything about the level of severity. That comes under a different part of the penalty regulations, under likelihood and negligence, whereas the history was simply raw numbers of violations. It wasn't intended to it wasn't intended to be like a double dipping situation that what the Secretary is talking about. That's why they have the 6 different criteria that the court follows. So our position is that, in essence, the Secretary wrote this regulation, it set forth a policy, and then it proceeded to ignore it. And, this case just happened to show a really extreme example of it, because GMS had 5 citations, but it was penalized for 15. And so it was just an extreme example, just to bring it to the court's attention that the Secretary wasn't following its own regulation.
All right, we've got your argument. Thank you.
Thank you.
Case number 22-5093, Adam Robinson versus Department of Homeland Security, Office of Inspector General. Ms. Cooney for the appellant, Ms. Lyons for the appellee.
Professor Wolfman, good morning.
Good morning, Your Honors. I'm Brian Wolfman for Appellant Adam Robinson, and I'm pleased to introduce Kira Cooney, Student Counsel in the Georgetown Appellate Courts Immersion Clinic, who will present argument this morning. Thank you.
Thank you.
May it please the court, I would like to reserve 2 minutes of my time for rebuttal. King v. Dole is clearly incorrect and should be overruled. This court should then grant Mr. Robinson equitable tolling because his one-day late filing was caused by the misinformation from the district court clerk that filing deadlines were not being strictly enforced due to the pandemic. Absent a clear statement from Congress, statutory time limits running against the government are non-jurisdictional and presumptively subject to equitable tolling. The instruction in section 7703B2 that claims must be filed within 30 days is a quintessential claim processing rule that merely instructs the litigant to take a certain step by a specified time. This mirrors the provisions found non-jurisdictional in Irwin 30 years ago, in Beckler last term, and in Wilkins just last month. And 4 other circuit courts that have expressly addressed section 7703B2 have determined that it is a non-jurisdictional claim processing rule. This court should follow the approach it took in Jackson v. Maudley when it overruled a long-standing precedent holding a statute of limitations as jurisdictional in light of intervening Supreme Court cases and sister circuit precedent.
For it to be considered non-jurisdictional, if we were to go that route, do we have to then also indicate that it's a claim processing rule? Or can we just stop at whether it's jurisdictional?
So once it's determined that it's non-jurisdictional, the court has kind of set up the Supreme Court has set up 2 different options. That is, in Hamer, it explains that either a rule is jurisdictional and that when it comes to time limits, that those are the only rules that are jurisdictional are those that transfer adjudicatory authority from one Article 3 court to another, whereas other time limits that govern transfer of authority from non-Article 3 courts to an Article 3 court are claim processing rules. So it has set up 2 different options between jurisdictional and claim processing rules. It could still be mandatory, but it would be a claim processing rule. And that is what the court determined in Jackson v. Maudley when it used an Irons footnote to overrule that prior precedent before it turned to equitable tolling, which, if there are no further questions regarding jurisdiction, I will now turn to.
So the whether something is claim processing is not jurisdiction, correct?
Yes, Your Honor.
And claims processing hasn't been raised at all by government in this case. So that argument is not even before us, is it?
So the government raised below whether or not the claim was
Raise it in its brief here?
So, excuse
Did
me?
it raise it in its brief here?
It did not raise it in
It
its
hasn't
brief.
mentioned claims processing, so that issue just isn't before us.
No, Your Honor.
Thank you.
I will now turn to equitable tolling. Equitable tolling is warranted on this
I'm
record.
sorry, can I back you up on one thing?
Yes.
I apologize. On the jurisdictional argument, the government argues that the provision issued here has a notwithstanding clause to introduce it. And that's different from other examples where time limits have been found to be non-jurisdictional. What is your response to that?
So the notwithstanding clause does not turn the provision into a jurisdictional hurdle because it does not speak in jurisdictional terms or to the power of the courts, which is what the Supreme Court has instructed is required for a jurisdictional rule in Kwai Fun Wong and in several other cases. The types of language that is jurisdictional is something along the lines of the tax court shall have jurisdiction, which is what the Supreme Court discussed in Beckler. There is no comparable jurisdictional language in Section 7703B2. This court should then grant Mr. Robinson equitable tolling because within only a 30-day filing period that began and ended during the COVID-19 pandemic, Mr. Robinson prepared a full federal complaint demonstrating that he was diligently pursuing his rights, and it was the misinformation from the district court clerk that created an extraordinary circumstance standing in his way.
But can an individual in a clerk's office overrule essentially any standing order by that clerk's office?
No, and we do not argue that the district court overruled the standing order, which did not itself toll statute of limitations, but it also did not abrogate equitable tolling where it would otherwise be available. I would also note that the standing order instructed that litigants with emergency filing should call the clerk's office for further information, and it is reasonable for a pro se litigant in Mr. Robinson's position to have thought that that suggested when he only had a few days left before the filing deadline to call the clerk. And then the clerk informed him filing deadlines were not being strictly enforced.
But aren't we also looking at extraordinary circumstances here, you know, for the equitable tolling argument? You have their diligence and then the extraordinary circumstances. But here, what would you say was outside of the litigant's control to get to that extraordinary circumstance?
Yes, it was the misinformation from the district court clerk's office that filing deadlines were not being strictly enforced. And so that information, it was reasonable for a pro se litigant, as many other courts have recognized, to rely and believe information from a government official or a district court clerk. And when that information is misleading or inaccurate, it may be sufficient to create an extraordinary circumstance out of his control. And the DC District Court recently recognized that in a case Farrell v. Fudge, which we cited at page 18 of our.
A lot of courts of appeals, though, have held that misinformation from a government official, while it might bear on diligence, is not itself an extraordinary circumstance. I had taken from your brief that it was COVID situation, and that's what necessitated calling the clerk's office. And in fact, the standing order, the very one the government relies on, instructed people who were not going to be to file during the daytime. If you weren't filing after hours, you can't use the drop box. And they were instructed to call the clerk's office for directions on how to make their filing. That's what the standing order said. And since presumably he wasn't planning to file it at midnight and use the drop box, he was trying to find out how to file in the daylight hours. And that it was that aspect of the COVID situation where the standing order told him, you can't use the drop box. You've got to get directions from the clerk's office. And sort of the COVID emergency situation that was causing the extraordinary circumstance.
COVID is relevant to the evaluation, and the court should consider the full set of circumstances, but it was the clerk's misinformation that creates the extraordinary circumstance.
But it was a COVID situation that instructed him to talk to the clerk's office to figure out how to make a filing.
Yes, Your Honor.
Because he couldn't use the drop box during business hours.
So what the standing order actually said was that litigants with emergency filings should call the clerk's office for further instructions. And that is what, assuming Mr. Robinson had awareness.
It also said there's a drop box we use after hours or if the clerk's office is closed.
Yes, Your Honor.
But the drop box cannot be used during business hours. Instead, you should call the clerk's office for directions.
Yes, Your Honor. As that is what Mr. Robinson did. He called the clerk's office for further instruction, and then the clerk's office informed him that filing deadlines were not being strictly enforced, which is what caused him to then mail his complaint. And as the government recognizes at page 26 of its brief, quote, the most that can be said of the evidence in the record is that the clerk's statement convinced Robinson that he could mail the pleading and risk it being a day or two or more late without consequence.
Didn't the clerk also say, just get it in? Just get it in here.
The clerk said, and this is at JA 59, that it's most important just to file. And so we think that Mr. Robinson, even though the clerk had said that filing deadlines were not being strictly enforced, the fact that he then chose to mail it that same day demonstrates that he continued to diligently pursue his rights. However, the government, as it concedes, the clerk had convinced Mr. Robinson there would be no adverse consequences by mailing it. And as the court has recognized in many other cases, justifiable reliance on a representation from a government official may be sufficient to warrant equitable tolling.
But how much do
is
we
there
need?
anything in the record that indicates he could not have done this electronically, which is what 99.9% of people do now?
No, Your Honor, but I would reiterate that Mr. Robinson does not bear the burden of showing what other paths he could have taken. He really needs to show that it was the extraordinary circumstance that caused the delay.
That was in the standing order, the option of doing it by e-file. That was in the standing order.
Yes, but what was also in the standing order was the instruction to call the clerk's office, and that is what Mr. Robinson did, and he then received misinformation that resulted in him mailing the complaint and caused the untimeliness.
And not to at all impugn Mr. Robinson's integrity or his character, but one of the things that concerns me is kind of this being a floodgates case from the standpoint that everybody could say, I called the clerk's office, but how much corroboration do we need? For example, a date stamp on that he actually had a postmark for that day, he actually put it in the mail, because you got a check that's a couple of days later. And so how much more corroboration would we need other than just saying, I called the clerk's office, ignore the standing order because an individual essentially trumps a written standing order out of the clerk's office?
So Mr. Robinson did include at J59 a reference to the telephonic record of his call, which occurred at 10:13 a.m. in the morning. And I would note that at this stage, this was at the motion to dismiss stage, Mr. Robinson was entitled to all reasonable inferences drawn in his favor and the evidence viewed in the light most favorable to him. I would also say that a floodgates problem is not an issue here because this is squarely within this court's existing precedent. In Gerald v. U.S. Postal Service, the court recognized, as I've mentioned before, that just the reasonable reliance on a government official may warrant equitable tolling. So we're not asking you to step beyond your existing precedent, and it aligns with recent DC district court decisions as well.
Let me ask you, how do you read notwithstanding any other provision of law? What do you think that refers to?
So we believe that notwithstanding any other provision of law merely instructs the litigant that he should look at the filing period in section 7703B2, which is 30 days, as opposed to looking for a contrary filing period in any other provision, such as the 60-day filing period in section 7703B1 or the 90-day filing period applicable to Title VII claims. So it really instructs the litigant that the relevant filing period for a mixed case is that in 7703B2 and not to look elsewhere.
Are you saying, because the way I read it is notwithstanding any other provision of law, you've got three other statutes directly above that, which do have their own filing dates. I mean, it seems to me it's pretty clear that notwithstanding any other provision of law, after you've cited three other provisions of law that have their own filing dates, that's what you're talking about.
Yes, Your Honor, exactly. So that is exactly our point.
All right, we'll give you a couple of minutes to reply.
Thank you so much.
Ms. Lyons, you're a familiar face.
Good morning, Your Honor. Nice to see you again. May it please the court, I am Jane Lyons from the U.S. Attorney's Office, and I'm here on behalf of the Department of Homeland Security's Office of Inspector General. Can you all hear me? I don't feel right. Okay. Everything's okay?
Yes.
So what we're here talking about today is initiating a civil complaint, a civil action, which requires delivery of the complaint or receipt of the complaint by the district court's clerk's office. I think I'd like to start with the language of the district court standing order, which has been discussed here at length this morning, and I think a bit incorrectly. The only direction for calling the clerk's office was for emergency or sealed filings. The first two sentences of paragraph 8 of Standing Order 20-9 say, quote, the clerk's office will remain open, although public access will be restricted. Electronic filings through CMECF will remain available, and here's the important part, self-represented litigants may date stamp and deposit papers in drop boxes available at the entrance to the courthouse. In other words, there's no change for regular civil business in the courthouse. And even more importantly, in the paragraph immediately above that, paragraph 7 in bold and underlined language says, statutes of limitations unaffected. Order does not toll any applicable statute of limitations. And in this case, we know that Mr. Robinson...
Did I misread or read something else when it said the Dropbox shouldn't be used during working hours?
A Dropbox may not be used for emergency and sealed matters.
Mm-hmm.
That's where you're told to call for additional instructions, which I think one would fairly guess would mean if you have an emergency or sealed filing, we will meet you at the door and take it from you, would be my guess. I don't know. But this is not an emergency or a sealed matter. This is one of the most routine things that happens in a courthouse. Someone has to file a lawsuit. And the initiation of a lawsuit under a deadline that Mr. Robinson knew from the notice he received from the Merit Systems Protection Board was statutory. Section 7703B appears in the notice. And he knew the deadline. We have no disputes in this case about when the deadline was or what happened when. And the record shows he was ready to file on the same day he had the conversation with the clerk. And the district court correctly held that he did everything he was going to do to file that day. So the conversation doesn't appear to have made any difference in what he was doing. The clerk did not tell him to use the mail. The clerk said, in sum and substance, just file, don't worry. Not file whenever you feel like it. So there's the language in the notice, the clerk's statement saying it's more important to file.
But he didn't
And the
file
city.
whenever he felt like it. He filed, from what he thought, he mailed it with 4 days from a suburb of Washington, D.C. The post office website itself would tell him it would be there within 2 days. He thought 2 days. The check was dated 2 days later. So this isn't a case of somebody who did it whenever he felt like it. The question was the middle of the worst time in the COVID pandemic. And the question is, do I need to go drive into DC and either go into a building or interact with other people, or can I just put a stamp and put it in the mailbox? And when I'm told just file, and we lawyers, we know, file, that can have different permutations. What does that mean? Sometimes mailing is filing, sometimes it's not, but he is pro se. So this isn't someone who wasn't diligent. I understand you're arguing about extraordinary circumstances, but he was not someone who was taking his time. And most of us would think if you mail something from the suburbs and into DC, that it's going to get there within 4 days.
Perhaps during ordinary times, Your Honor, but I think the pandemic sheds a different view of that.
So the pandemic is an extraordinary circumstance from the government's perspective, but not from his?
No, that's not what I'm arguing. I'm arguing that as in Young versus SEC.
Was the mail slowed down? I don't even remember that. I don't remember that part of it.
I don't remember. What I remember from that time, honestly, Your Honor, is that I used to collect the mail out of the mailbox and leave it in a box for 3 or 4 days before I touched it because we were afraid we'd get COVID from the mail.
Maybe the clerk's office did the same thing.
No, there's no evidence to suggest that on the record. A party in Young versus SEC, the court held that when a party's lulled into missing a deadline, missing a formal deadline by a court order or a ruling, but that doesn't apply to statements made by the clerk's office staff. That's something the court has ruled as sort of out of bounds to rely on to excuse what you're doing. And Houston v. Lack, in the Supreme Court case, Houston v. Lack, the Supreme Court talks about why there's a need for the prisoner mailbox rule, why prisoners can't do it. And the reason it ultimately is they can't rescue themselves if there's a last minute problem. If they mail something in and it isn't or hasn't arrived as expected, they can't rescue themselves. And the real issue with Mr. Robinson's record here is that he has not made any additional efforts after he's mailed to ensure the timely receipt. He doesn't say that he checked his bank account to see if the cash was checked. He doesn't say that he ever considered going to the clerk's office at the last minute on Thursday or Friday with another copy of the complaint to make sure it was in on time. And that's what reasonably diligent people would do.
Were people allowed to go into the clerk's office at that time because of COVID?
Pardon me?
Were people allowed to physically enter the clerk's office?
People were allowed to enter not the clerk's office, the courthouse, to put things in the drop box, which is the same thing.
I know, but he thought this was an emergency filing. He's pro se. He was told not to do that. That's the confusion here.
He was not told not to use the court's Dropbox, Your Honor.
He was, if he thought it was an emergency filing, he's thinking, I've got only a few days. Maybe he doesn't know what an emergency filing is.
Well, maybe, but the gaps in the record shouldn't be filled in by this kind of speculation.
Well, should they are we at the 12B6 stage here?
No, that is not the proper standard to evaluate. In carrying a burden, and there must be some.
Yeah, but we evaluate burdens all the time differently. We evaluate the burden to state a claim at 12B6 differently than we evaluate the burden to sustain a claim at summary judgment. I'm not changing the burden here. I'm just saying, do we need to make inferences at this stage until there's more information?
No, Your Honor, I don't believe so. The burden here is of a showing to carry a burden of proof that.
Sure, complaints have to show a claim.
This is
and we
not
do
about
that
the
differently.
complaint.
No. But I'm saying that show doesn't make a difference here. The question is how much you have to show at the preliminary 12B6 stage, as opposed to, say, summary judgment, after there's discovery and development of a full record. I mean, district courts would be well within their discretion to say, all right, time out. Let's just figure out, before we go any further, let's find out exactly what was going on for this equitable tolling claim and have, I don't know if he needs discovery, if you all needed to ask some questions or interrogatories to get the record fleshed out. If he wants to have a chance to flesh the record out more, then that can all get resolved.
This is the kind of issue that's typically resolved at the outset of the case. It is a defense that the.
No, but it's a very factual one. It's kind of unique for
But the facts
in
are
that way.
all in the possession of Mr. Robinson that matter.
Mm-hmm.
And he had the opportunity to provide them. He had the assistance of counsel to provide a second declaration here,
Right,
knowing that this had been.
But we need to take, how do we view those facts and the reasonable inferences from them? That's what I'm asking you at this stage.
You review these facts to see if they establish the burden of.
And take reasonable inferences from them in his favor.
I don't believe he is entitled to reasonable inferences, but not too far. They have to be well supported to show reasonable diligence and extraordinary circumstances shown to have prevented timely filing. And I know.
But we held that
standing
you
here-
don't take reasonable inferences at this stage, not to change the burden, but just to determine whether the burden is met. That's all I'm asking. Have we held that for other courts?
I don't think we have a clear ruling on exactly that. Sometimes in this sort of situation, there's a presumption, but there are no real presumptions that apply in this context.
Right. Okay. Did you have any arguments on the, we don't have to get to equitable tolling if there's not jurisdiction. I didn't know if you were just resting on your brief on that or had.
No, I'd be happy to address that, Your Honor. Just wanted to make sure I didn't want to say anything else. On the equitable tolling, our basic position on the equitable tolling is nothing thwarted his reasonable efforts to get the complaint thereon. Turning to the King versus Dole argument, that's what you're asking me about, correct? There are a number of reasons for not using the, I think of it as the express lane for en banc consideration. First, the court's already rejected it in full in this case, and there are good reasons for that. I have to be careful today to keep my job because only the Solicitor General of the United States is able to present arguments, and the Solicitor General has not approved any of the arguments I wrote up in draft briefs for presentation to the court. So, but I would say, because I was also the lawyer in Jackson versus Motley the last time you used Lawrence footnote. So maybe there's a set of steak knives in my future, but this time I want to talk about it. The court has emphasized that the CSRA is a particularly comprehensive remedial scheme, and Congress was unusually intentional in creating and depriving people of rights that can be seen to be in somewhat similar situations. And of course, I refer to the court to cases like Feilbark versus Department of Transportation, Fornaro versus James. These are familiar. Here, administering this statute, Judge Henderson, you were looking at the different sections of the, immediately preceding language. There is no doubt that today, under one of the previous sections in the Federal Circuit, Mr. Robinson his claim would have been dismissed for untimeliness because the Federal Circuit is regarding that its own time limitation as jurisdictional. And so there's a fairness across the application of the CSRA here. Of course, I already say this, the court should have the benefit of the Solicitor General's views on why this should happen.
I'm sorry, I'm just a little confused on what we need the Solicitor General's views on.
You need the Solicitor General's views on whether to overrule King versus Dole. The benefit that you will get from a fully articulated and considered thing.
The Solicitor General doesn't usually get involved as the appellee stage.
Correct. The Solicitor General's office becomes involved when there is a petition for rehearing. And we are asked to initially provide a response to a petition, and then they typically are involved beyond that.
Okay.
The other reason to be cautious here is that just the fact alone of whether the provision is jurisdictional is not the end of the inquiry in terms of equitable tolling, because Supreme Court has more recently, including in January of this year, in Arellano versus McDonough, recognized that equitable tolling can be disallowed in even non-jurisdictional provisions. So even solving the jurisdictional issue doesn't necessarily end the inquiry here.
Do you think there's anything in the language here that would foreclose application of equitable tolling?
I believe that notwithstanding any other provision of law language could be read to include the doctrine of equitable tolling. The doctrine of equitable tolling has existed longer than the Civil Service Reform Act, and it is at least possible that it is swept within that language. Yes, Your Honor. And that language is particularly clear and emphatic because, and this was part of what led the court in King versus Dole, but it says, notwithstanding any other provision of law, any such case filed under any such section must be filed within 30 days. I mean, I know this is much like language in other statutes the Supreme Court has considered, but the Supreme Court considered this very provision in Lindahl and at least has not come back. And in terms of how
Also
often
considered
this
it in
comes up,
Kleckner and said it's just a plain old time of filing provision. Kleckner versus Solis. I'm saying Kleckner, right? Versus Solis. It's just this plain old routine, ordinary time of filing provision.
there's been a lot of writing on these issues.
There
I think we
on the
can agree
statute,
about
for
that.
sure, for sure. It's a messy statute.
And it's worth the benefit of very careful consideration before overturning both this court's precedent and recognizing that Lindahl may have been overcome. Court have any further questions?
I don't think so. Thank you.
We respectfully ask that you affirm and not use an iron sweep.
Thank you. Ms. Cooney, why don't you take 2 minutes?
Thank you. Very quickly, despite the notwithstanding language, I would like to know that 4 other circuits have determined post-Irwin that equitable tolling is appropriate for Section 7703B2. Regarding the equitable tolling issue, the pandemic is relevant here because it renders Robinson's conduct reasonable, and he has met his burden of showing that the misleading information caused him to put the complaint in the mail. The government is free to prove otherwise with additional evidence on summary judgment. I'm happy to address any further questions you may have.
Yes. Thank you.
Thank you.